this video, I want to talk about the worrying implications of the Lucy Letby trial for justice in general. I hesitate to make this video because I know that some people, for example, Chris Morris in Lucy Letby Analysis, have done some incredibly deep research, and I probably haven't looked into things in anything like as much detail. But I'm going to make the video nonetheless because I think I'm bringing up things that haven't been brought up before. I apologise for the state of my voice. I'm recovering from the flu, so I could be a little hoarse at times. This is a case which could affect every one of us because the legal principles which have been applicable throughout our lives have now been completely overridden. British law, as far as I'm aware, is based on precedent, and the Lucy Letby case has established new precedents, and those are going to be effective for every case in the future. You have to remember that. British law is based on precedent. In particular, the following legal principles have now been cast aside, and we, the public, no longer can regard the law as offering any protection whatsoever against miscarriages of justice. So what, you may ask, are the legal principles which have been cast aside? Now, I've only dealt with the ones that are, the central ones. There are others as well, which have played a big part in finding Lucy guilty, but, they are not as crucial as these three, which I'm going to talk about in this video. The first one is habeas corpus. The second one is the notion that an accused person is innocent until proven guilty. And the third is that for a criminal case, you should be found guilty beyond reasonable doubt. That's the case for all criminal cases. Guilty beyond reasonable doubt is the measure, and for civil cases, it's a balance of probability. So all those three legal principles have been cast aside by the Lucy Letby case. Starting then, with the habeas corpus. Habeas corpus, I think I first heard about it when I was at school, and it was associated with the Magna Carta. And from my Latin, at school Latin, I know that it means you have a body. In other words, you are holding a living person. And the idea is that you should not be able to hold somebody, to have them incarcerated for any length of time you wish. That there should be a limit to the amount of time that you can hold somebody until you have proven them to be guilty. So habeas corpus, how does it apply to the Lucy Letby case? Well, I think I'm right in saying that she was arrested in 2018 for the first time, 2019 for the second time, and 2020 was the third arrest. And at that point, she went to jail until the trial in 2023. The trial was 10 months long. So I believe she was in jail on remand, as it were, for 2 to 3 years. And at that point, she was still officially innocent. You remember, she was not declared guilty until the end of the trial, the 10-month trial. So this is a change that has crept into the legal system. There is no longer any emphasis on the amount of time you can hold somebody in jail simply accused of a crime, but not found guilty of that crime. And that's a very serious thing, because nobody wants to find themselves in jail without trial, which is what is happening. So how did this happen? Well, I remember that, we had various accounts of terrorism. I'm not going to say too much about that. I don't want to be accused of being a conspiracy theorist. But the fact of the matter is that the terrorism was used as an excuse to get rid of habeas corpus. So they started to alter the rules about how long you could be held before being found guilty. I would add that in Lucy's case, her ordeal was actually much, much longer than the time she was in prison on remand prior to the trial, because, even before that, she was accused of dreadful crimes with no evidence whatsoever, just a gut feeling on the part of Dr. Breary in particular. And she went through a grievance procedure, which must have been harrowing. She won the grievance procedure, which was indicative of that there was something seriously wrong in that hospital. The fact that she won the grievance procedure, I think she deserved to win it. And there were things going wrong. The fact of the matter is she suffered a great deal, and we must never forget that. I want to deal secondly with the second principle that's been overridden, and that is the principle that an accused person should be regarded as innocent until proven guilty. In Lucy's case, she was very definitely regarded as guilty until proven innocent, and that is now a precedent. So we start with the police interview, and I've taken this from the Daily Mail podcast that I listened to, and this was an interview by a young woman, very young woman, called Detective Sergeant Danielle Stonier. In my opinion, she was a rather empty-headed young woman, over-promoted. I don't think somebody of her age should have had the position she had, and I don't think somebody of her age should have been interviewing Lucy at all. It was a very serious case, and you should have had somebody with a great deal of experience. She interviewed Lucy for over 20 hours. Funnily enough, she says she was a family liaison officer as well as being an investigating interviewer. And that in itself is a huge conflict of interest, because I think it's fairly obvious that she would have gone from interviewing Lucy and then spilling the beans about everything she'd found to the families involved. So when they gave evidence in the court case, they would obviously have been brainwashed beforehand. I can't say that happened for certain, but I would guess that it did happen, because she seemed to be a very gossipy young woman, and she seemed to be starstruck. She was very immature. She says, for example, when she first saw Lucy, and I quote, "It was quite surreal to see her in person." I suppose it wouldn't have made a very good story with her friends down the pub if she had said that she interviewed this young woman who was obviously innocent of any crime. It would be much more exciting to be able to say that she interviewed a serial killer. And I felt she was completely starstruck and enjoying the idea of how important she had become. I found it very distasteful, actually, but that's my opinion. We're told that at that point they had what they call the medical evidence. And when they talk about the medical evidence showing inflicted harm, they're talking about Dr. Dewi Evans's theories, because it wasn't evidence, it was theories as to what had happened. And she says, so Lucy knew what she was up against. She spoke about the fact that during both interviews that Danielle Stonier, I think she heard the first interview and then took part in the second interview. Lucy had spoken, and the person interviewing Danielle Stonier says, "Why do you think she spoke?" In amazement. Well, I mean, it's obvious to us that Lucy spoke because she was innocent, and she innocently thought that the police would see the light and understand that, that she hadn't done anything wrong. That was why she spoke. But Danielle Stonier replies to that question, why do you think she spoke? And I'm quoting here from the podcast. Quote, "I think what we have to remember is, obviously we're there as interviewing officers, but we're there as investigators as well. And so for me, we're putting the evidence to you. And this is your opportunity to tell us any involvement you've had or not had. If you're saying to me, this is not me, I am not responsible for the allegations you're putting towards me, that is not me, I have not done these things, What? Okay, tell me what lines of inquiry to follow to prove that you aren't involved." You kind of make it a two-way thing, You're letting them know why we think they may have involvement, but also, right, okay, if it isn't you, you tell us. Tell us where you were during these times, or tell us where to go to look for that bit of evidence if it could assist in proving your innocence. So I think it's clear from that the police don't have to prove that you are guilty. You have to prove that you are innocent. You are guilty until proven innocent, not innocent until proven guilty. I think that the podcast of Danielle Stonier makes that clear. And it didn't end there. In his closing speech, the prosecuting barrister, Nick Johnson, goes through the list on the indictment, spelling out Lucy's interpretation of what happened to each baby. You only have to listen to part of the interview given by the worldwide experts. I'm talking about Li Shu, etc., who gave their opinion pro bono to realise just how complex this case was. There is no way that Lucy Letby, a nurse, and a very good nurse, but nevertheless a nurse, could analyse in detail what we heard with the panel of experts was an interacting cascade of events which resulted in these babies' deaths, one thing having a knock-on effect on the next thing, which had a knock-on effect on the next thing, etc. It was quite complex. Dewi Evans memorably said, "Babies are simple things." Well, I got the impression they were anything but simple things, actually. Lucy could not possibly prove her innocence. And she couldn't sum up, I don't know how many deaths and assaults she was accused of in the end. She couldn't possibly go through it all. It was an unreasonable thing to ask her to do. But the fact that she couldn't do that was regarded as proof of her guilt. Mr. Johnson says for Child A, and I'm quoting here, "Letby said there were issues with the long line, and if we agree it was an air embolus, that Melanie Taylor would have done so." So he's already, not only is he unfairly quoting what Lucy is supposed to have said, but he's suggesting she's just putting the blame on somebody else because she's trying to get out of what she's done. This is really underhand and it's very unfair. Mr. Johnson says child A did not die of dehydration, and it was not Melanie Taylor who supplied the air embolus. How does he know? You know, I'm not suggesting that it was Melanie Taylor, by the way. I think there wasn't a crime, quite simply. But, you know, he's saying things here in a very definite way, and he could not possibly know what he's talking about. For child B, nothing. So that's a crime. If Lucy can't say how child B died. For child C, nothing. So obviously she must be guilty if she can't work out the complex reasons for the death of child C. For child D, Letby said there was a delay in antibiotics, but child D did not die from an infection. Yes, but the child D could have died with an infection. It might not have been the final cause of death. I don't know. I can't remember the details of how child D was supposed to have died. But, you know, he doesn't seem to realise that these are complex matters. And he's trying to make it very simplistic and to suggest that if Lucy can't give the details that the panel of experts took a long time to work out. They were hours working out for each child. They had 2 people working on each child, and these were the highest qualified neonatologists that you could imagine, and they took a long time to work it out. I'm sure many hours, not 10 minutes like Dewi Evans. And, you know, if she couldn't work it out, then obviously she must be guilty. That was the suggestion. In other words, she had to prove her innocence. They did not have to prove her guilt. Finally, we've got probably the most important legal principle of all, which is the principle of beyond reasonable doubt. As I've said before, the principle is for any criminal case, you have to be found guilty beyond reasonable doubt, whereas for a civil case, you can be found guilty on the basis of a balance of probabilities. I'm dealing mainly with the main reasons why Lucy, the principle of being beyond reasonable doubt was cast aside in the Lucy Letby trial. First of all, the judge barred a considerable amount of evidence. The RCPCH report, I'm not sure that I've got the acronym letters right, around the right way there, the report that was written into the hospital, which was very, very detailed, and explained the suboptimal care, the relationships between the staff, which were crucial. The fact that the staff were overworked, that conditions in the hospital were dangerous, the sewage that was leaking from the ceiling and the sinks. The judge decided that wasn't relevant, which was incredible actually, because it was absolutely crucial evidence. And if you're up on a murder trial and the judge can say, well, you know, I'm not listening to that evidence, or I'm not listening to this evidence, you know, you're in an impossible situation. With regard to the sewage, Johnson, the prosecuting barrister, made the fatuous statement, I couldn't believe it. He said that the sewage that was had backed up into the sink and dripping from the ceiling, that didn't occur at the time it didn't coincide with the deaths of the babies, so it wasn't relevant. I mean, could he not imagine that, you know, serious bugs like Pseudomonas and E. coli and all the rest that were in the taps in the system would have stayed dormant, perhaps on the ward, but would be multiplying all the time, and it didn't have to coincide exactly with the deaths of the babies to be relevant. I can't understand how the jury didn't see that he was talking rubbish. There was also the grievance procedure, which was not mentioned, but was, well, I think it was mentioned, but they weren't allowed to show any conclusions from the grievance procedure, but that procedure was very important in showing the motivation, possible motivation, let's say, of the two main accusers, Dr. Breary and Dr. J.R.M. And I would say that, this inadmissibility of crucial evidence proved to be a huge obstacle in proving that that Lucy could not be found guilty beyond reasonable doubt. But the whole question of beyond reasonable doubt goes much further than that even. The decision was made by the judge, and this was a crucial decision, that if the jury found a number of murders in this case, that they could, in cases where they weren't sure, infer that they were also murders. He said they didn't have to be able to see any motive for murder, and they didn't have to even know how the murder had taken place. If they had found her guilty of even just one murder, then they could infer that the other cases were also murders. And in the case of baby K, there was no conclusion. So the judge ordered a new trial, and it was the same judge and the same prosecuting barrister. And I can't see the point of this new trial at all, because the prosecution at the beginning listed all the murders, and then the jury were told that they could infer guilt. They didn't have to find Lucy guilty of the attempted murder, I think it was, of baby K. They could just infer the guilt because of the other murders which she had been found guilty of. Did the judge emphasise or indeed mention reasonable doubt in his closing speech? I somehow doubt it. But it's very difficult to know because, in this judicial system where we have the internet of all things, and you could easily put the whole case up, the transcript of the whole case on the internet, you have to pay £100,000 apparently to have a copy of the whole transcript. So I've seen some of the closing speech of the judge, the instructions he gave to the jury, but I haven't seen it all. So I cannot say that he did not mention reasonable doubt in his closing speech, but I have the suspicion that he probably didn't. Please let me know if I'm wrong about that. Looking more closely at this business of inferred guilt, I think it's a very, very serious precedent. I'm going to take an example, a hypothetical example, using the letters A, B, C, D and E. And this, I'm not making reference to any of the babies, A, B, C, etc. at all here. I'm just using letters for hypothetical crimes. So you've got somebody who is found guilty of 3 murders, let's say, A, B and C. And the judge tells the jury that they can infer guilt for D and E because the jury are not sure about D and E. They don't know whether to find the accused guilty or not guilty for D and E. So the judge says, don't worry about it, you can infer guilt. Not only that, but you don't have to worry about being unanimous. That has gone by the board. And, one member of the jury decides that they can't stay for the end of the trial. You've got 11 good men and true rather than 12. That's fine. So we've got A, B and C guilty and D and E guilty by inference. Okay, let's assume we go next to the Court of Appeal. And the Court of Appeal finds new evidence which shows that the murders of A, B and C could not have taken place. that the accused was obviously innocent of those murders A, B and C. Well, tough luck, because that person is still in jail for the rest of his or her life because of the inferred guilt for the deaths D and E. So if we look at the three legal principles that have gone by the wayside, if you like, habeas corpus has gone. The notion of innocent until proven guilty has gone. Lucy Letby case has shown that you are now guilty until proven innocent, and you have to prove your own innocence. The notion of beyond reasonable doubt is gone. But you might say, well, in a murder case, it's now the same as a civil case. You're found guilty on the basis of the balance of probability. But it's not actually true, because in a civil case, you have to be found guilty on the basis of the balance of probability. You can't infer guilt in a civil case. In a murder case, you can now infer guilt. So the bar is lower now for a murder case than it is for a civil case. Now, I have to say I'm not a lawyer, but I'm just using ordinary common sense, and I stand corrected if I can be shown that what I'm saying is wrong. I don't think it is wrong, and I think it's very serious. I would like to say one final thing in relation to Lucy. This is a terrible miscarriage of justice, and every day she's in jail, every day that the Criminal Review Court, or whatever it's called, ponders the case and spends hours and hours discussing the case, and but never coming to a conclusion. Every day she's in jail is a crime against her. She should be freed immediately. If they want to look into the case in more detail, do so, but she should be freed in the meantime. That's my opinion. Thank you for listening.